Hello and welcome to yet another episode of the In News series. I am Pooja Dwivedi. Today we are going to discuss the controversy behind the sources on which journalists rely upon for information. Now, the sources should be revealed or not. This is one of the major bone of contention that in today's democracy, it needs to be discussed from the perspective of your prelims examination as well as from the perspective of GS mains paper 2nd and 4th. So without any further delay, let us move ahead with the news piece. Court says journalists not exempt from disclosing sources. We do not have any laws regarding that. So what is the law? Well, the Supreme Court broadly recognizes the freedom of press, which is the right of journalism to ensure protection of their sources, whereas courts have ruled differently on the issue. So we will go by the rulings. We will also look at the position of such cases in different countries. Other than that, of course, we have to look at the issue, the overall issue. What did the court say? So the news says that a Delhi court on January 19 said that there is no statutory exemption in India to journalists from disclosing their sources to investigating agencies, because it is important on a need-to-know basis. Investigation agencies such as the CBI, they need information if any such information is important from the perspective of the case. So, the Delhi court has said that. This is with respect to one very important leader of Uttar Pradesh. The CBI had sought to close its investigation on how certain news channels and newspapers had aired and published disproportionate asset cases against the late Samajwadi Party and his family members on February 9, 2009, which was a day prior to the scheduled date of hearing in the Supreme Court. So the problem is, how did they get the documents or the information regarding that? So documents, according to the CBI, used by the news channel were forged. This is what they are saying. But it couldn't be established that who forged the documents, and that is also the reason that there is no sufficient material evidence to prove that there was a criminal conspiracy. So, because of the lack of source, this case is said to be closed by the CBI. But Chief Metropolitan Magistrate of the Rouse Avenue Court rejected the closure report, asking the CBI to find out the modus operandi which was adopted in order to access these documents. And also it involves probing involvement of any insider in the act alleged. So if there was any insider, how did the access of document happen, and what is the condition or what is the situation with respect to investigating any internal source that was available for that source. So this is not going to be closed according to the magistrate. So now what happens that we do not have a specific law, and that is the reason that we see so much issue. In India, no specific legislation has been there which can protect the journalists from being asked to disclose their sources. See, freedom of expression, that means freedom of press, is entailed under Article 19. It is available to every citizen. But investigative agencies can issue notice to anyone, including journalists, to provide information given the sense that they need to know, they have a right to know for their expression. Like any citizen, a journalist can be compelled to give evidence in the court, and if she or he says, I cannot do that, then they can be tried under the contempt of court. Now, freedom of press, okay, right of journalists to ensure protection of their sources, Pegasus spyware. This is one of the case that we need to talk about over here. See, in October 2021, the Apex Court said that one of the fundamental conditions for the media to exercise its right to freedom of speech and expression is under Article 19, and it entails the protection of journalistic sources as well, because in a democracy, it is important to conserve the sources so that people can exercise their powers freely. So what happens that in any democracy, it is also important that we save our journalists, because in Pegasus case, the mobile phones of many important journalists were also hacked. So protection of journalistic sources is one of the basic conditions for the freedom of press. Without such protection, sources may be deterred from assisting the press. If it is going to be revealed, then what will happen? The sources will not help the journalist, and that will create a problem for the democracy and then for the people as a whole. Moving ahead, 2019, there was a review petition in the Rafale case, in which the Supreme Court overruled the centre's objection on petitioner's claim. Since they relied on purportedly stolen confidential documents, the centre asked the chairman of the Hindu publication to reveal their sources about this. So N. Ram told the court that the publication was perfectly justified in public interest. This was the statement made by the chairman of the Hindu group. So the absence of a specific law, it is often at the discretion of the court because there is no law. So courts have in public interest asked the journalists to disclose their sources, so it may become more reliant, right? So what have the courts said on the issue right now? According to Press Council of India Act of 1978, powers of the civil court to deal with complaints when a newspaper has offended against the standards of journalistic ethics, because there is a set of ethics that every journalist needs to follow, or public taste that an editor or working journalist has committed any professional misconduct. Okay, so this lies in the Press Council of India Act of 1978 only. However, the council cannot force any newspaper or news agency, journalist or editor to reveal their sources during the proceedings. Okay, so Law Commission of India, in its 93rd report of 1983, it recommended recognizing journalistic privilege by amending the Indian Evidence Act. Okay, and it said this here the Law Commission said that no court shall require a person to disclose the source of information for which he is responsible and where such information has been obtained by him on the express agreement or implied understanding that the source will be kept confidential. Alright, and in its 185th report on the amendments to the Evidence Act, this was repeatedly said in that report as well. So in United Kingdom, there is Contempt of Courts Act of 1981. It creates a presumption in favor of journalists so that they can have their sources saved. And who wants to protect the identity of their sources? This has been, preserved by the UK. And also, a European court also said that any person who asks any journalist to reveal their sources can be tried under the European Convention on Human Rights. Then comes United States. See, the First Amendment already guarantees freedom of speech in the United States, and it also mentions the press so that there is not any open-ended terms. Journalists do not have the right to refuse to testify in a federal grand jury proceedings and disclose sources. This was all settled in the 1972 case of Brandsburg versus Hayes. Alright, now Sweden, the Freedom of Press Act in Sweden talks about a broad protection of rights of journalists, and even it extends to state and municipal employees who are also a source, sharing information freely. And in fact, there a journalist who reveals his or her source without any consent may be prosecuted at the behest of the source. I am the source and the journalist has asked information from me, but I am saying that please do not reveal my identity. The journalist chooses to reveal my identity without my consent. Then the journalist can be prosecuted on my behest. Okay. So I hope all this has become clear. I will attach a question in the comment segment. You have to answer it and give me the answer for it so that I can announce your names. That's it. Thank you so much for watching.